Your Honour, please accept my application to have the recording of the interview between my client and the police excluded from evidence. This is due to it being obtained improperly, and also that it ought not to be permitted as provided by Section 130 of the Evidence Act, Queensland. Now, the arguments which support my application are based on the following submissions. Submission 1, that the evidence should not be excluded due to its unfairness against the accused, and also Submission 2, the evidence should be excluded as a matter of public policy. Now turning to Submission 1, evidence which is gravely prejudicial to the accused, despite any tenuous grounds for holding it admissible, should be excluded due to unfairness. And unfairness occurs when the probative value of evidence is outweighed by the harsh prejudicial effect. And this was discussed in the cases of Christie and Hasler. Now, admissions made during this interview could clearly have a high prejudicial effect, especially if they include any admissions of guilt or involuntary confessions. So this would have a high probative value. However, this high probative value may be lowered by a failure of police to recognise and respond to any cultural elements at play. Section 21 of the Evidence Act requires that cultural background be taken into account, and that issues surrounding language, such as slang and jargon, and also any cultural issues such as avoidance of direct questions, eye contact, silence, and gratuitous concurrence, must be taken into account by police. The accused here is Indigenous, and there is nothing in the facts to suggest that the police took these factors into account, and this could have led to any false admissions of guilt by the accused, and also possibly any involuntary confessions. This would severely undermine the probative value of the evidence. Now, when considering judicial effect, evidence will be prejudicial only when the jury are likely to give the evidence more weight than it deserves. And if the accused made admissions during an interview admitting to guilt of the crime, then this is extremely likely that the jury are going to attribute more weight to this evidence than deserves, despite any low probative value. Therefore, there is a clear argument for exclusion due to unfairness and due to the combined effect of the low probative value and the high prejudicial effect of the evidence. Now turning to Submission 2, since cases such as the Crown Island and Bunnings and Cross, it is long-standing policy that convictions obtained by unlawful evidence are unfair on the accused, and such evidence should be excluded. This is also due to public policy in that they want to deter calculated disregard of the law by those empowered to enforce it. The facts show multiple breaches of the Police Powers and Responsibilities Act, and this may cause the evidence to become inadmissible. So the breach provisions include Section 403, subsection 1, which requires the police to detain a person for a reasonable time, not amounting to more than 8 hours. Here, the accused was detained for over 9 hours, and there was no attempt by the police to obtain an extension. Section 420, subsection 2b, there was a failure to notify or even attempt to notify a representative from a legal aid organisation that the accused was in custody. There's a section 420, subsection 4, a failure to allow the accused to speak to their support person in private prior to the interview. And Section 421, failure to allow a child to speak to their support person in private. Now, unlawfulness of conduct is determined by applying the test in Bunnings and Cross, which considers the following 5 factors. 1 was the breach genuine mistake. Here, there have been a number of breaches combined with the severity of breaches implies more than a mere overstep by the police. It applies something more systematic and deliberate, and therefore this carries in favour of exclusion. If a deliberate breach will be excluded unless it is vital to the Crown's case, in which case the cogency of the evidence must be considered. Here, there is a deliberate breach and the evidence is vital to the Crown's case, so we must consider cogency. Now, in order to determine cogency, I refer Your Honour to the previous discussion surrounding probative value of the evidence in Submission 1. Low probative value of evidence indicates low cogency, therefore this weighs in favour of exclusion. Element 3 was the conduct of genuine response to pressing circumstances. Here on our facts, the accused was in custody for a significant period of time with no opportunity to leave, so he was detained. And also several provisions that were breached could have easily been complied with, such as just making a phone call or allowing a few minutes for the accused to speak to their support person. The application for an extension may have taken a longer time, however the application might have been likely to be rejected anyway due to unreasonable to detain a minor and also someone who is Indigenous for longer than 8 hours. Therefore, these facts that I just discussed suggest that the breaches were not a genuine response to pressing circumstances, as the circumstances just weren't pressing. The fourth factor to be considered is the gravity of the charge. Here it is a murder charge, this is a serious charge, and therefore this element does not weigh in favour of excluding the evidence. And also the final element, did the conduct breach any legislation? Here the police breached the PPRA. The purpose of the PPRA is to prevent and regulate conduct of police, to make sure evidence is obtained properly and legally, and it's also to prevent the abuse of institutional power against individual members of the public. So therefore this is potentially a clear example of exactly the kind of conduct this legislation was created to prevent. So this weighs in favour of exclusion. Now, after considering this, so 4 out of the 5 factors here weigh in favour of exclusion, which creates a significantly strong argument for exclusion on public policy grounds. However, the court may still admit the evidence if it believes that it would be in the interests of justice to include it under section 439 of the PPRA. However, this is unlikely in this circumstance due to the flagrant and severe nature of the breaches and the fact that most of them could have been easily complied with anyway. So therefore it suggests that it would not be in the interests of justice to admit them. Finally, Your Honour, I just want to submit that these facts seem to indicate strong arguments both for the public policy grounds and fairness discretion. However, I truly believe that the evidence should be excluded on public policy grounds. However, it respectfully is up to Your Honour to determine this fact. Thank you.